Be ready. Start. India is acclaimed for achieving a flourishing constitutional order, an inventive and activist judiciary, aided by a proficient bar and supported by the state. However, the courts and tribunals which the citizens are expected to approach for redressal of their grievance and protection of their fundamental constitutional and legal rights are beset with the problems of delays and costs. In a country where 36% of the population live below the poverty line, these deficiencies in the justice delivery system prevent a large segment of the population from availing legal remedies. The disadvantaged and poor are deprived of access to justice because of the cost of litigation, both in terms of actual expenses and lost opportunities, and the laudable goal of securing justice, social, economic, and political, enshrined in the preamble to the Constitution of India, remains an illusion for them. The infrastructure of courts and the processes which govern them are simply inaccessible to the poor. The state, which has been mandated by Article 39A of the Constitution to ensure that the operation of the legal system promotes justice by providing free legal aid and that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities, has not been able to create an effective mechanism for making justice accessible to the poor, downtrodden, and disadvantaged. In last 2.5 decades, the institution of the legal services authorities has rendered yeoman's service in the field of providing legal aid to the poor, but a lot is required to be done for ensuring justice to economically deprived section of the society and those who suffer from other disabilities like illiteracy and ignorance. We have already noticed that the personal and living expenses of the deceased should be deducted from the income to arrive at the contribution to the dependents. No evidence need be led to show the actual expenses of the deceased. In fact, any evidence in that behalf will be wholly unverifiable and likely to be unreliable. The claimants will obviously tend to claim that the deceased was very frugal and did not have any expensive habits and was spending virtually the entire income on the family. In some cases, it may be so. No claimant would admit that the deceased was a spendthrift, even if he was one. It is also very difficult for the respondents in a claim petition to produce evidence to show that the deceased was spending a considerable part of the income on himself or that he was contributing only a small part of the income on his family. Therefore, it became necessary to standardize the deductions to be made under the head of personal and living expenses of the deceased. This led to the practice of deducting towards personal and living expenses of the deceased one third of the income if the deceased was married and one half 50% of the income if the deceased was a bachelor. This practice was evolved out of experience, logic, and convenience. In fact, one third deduction got statutory recognition under the second schedule to the Act in respect of claims under Section 163A of the Motor Vehicles Act 1988, the MV Act for short. But such percentage of deduction is not an inflexible rule and offers merely a guideline, though in some cases the deduction to be made towards personal and living expenses is calculated on the basis of units indicated. The general practice is to apply standardized deductions. Having considered several subsequent decisions of this court, of the view that where the deceased was married, the deduction towards personal and living expenses of the deceased. Here we are dealing with a case in which the deceased had 8 dependents, including 4 sons and 1 daughter. The question which arises for our consideration is whether in 1992 a person having an income of less than rupees 3000 and a family of 9 could think of spending one third of his income on himself. On a conservative estimate, it is possible to say he would have spent at least 50% of the income on the purchase of food grains, milk, etc., and for payment of water, electricity, and other bills. 25% of the income would have been spent on the education of children, which would have included school stroke college fee, cost of books, etc. 15% of the income would have been used for meeting other family necessities like clothes, medical expenses, etc. He would have then been left with 10% of his income, a portion of which could be used to meet unforeseen contingencies and on the occasion of festivals. Thank you.